All right, we're still on the record in 2024 CR 3533 State versus Alex Neosek. Still on the oath, and defense is still your witness.
Thank you, Judge. Oh, okay. I thought she was asking me to wait.
It's your witness.
Yes, ma'am. Ms. Wise, in the aftermath of the incident, so since the day of the incident, you have not seen Alex, correct?
Except that on Friday, he got some of his belongings. I have not seen him.
Okay. There's really not been any communication, any contact or anything like that. And this was in February the 8th, correct?
Since
Okay. In the immediate aftermath of the incident, for about a week to 10 days, do you recall texting Alex? Yeah, for about a week to 10 days in the immediate aftermath of February 8th, do you recall texting Alex?
Yes, sir.
And for about a week to 10 days, would you agree with me that it was a one-way texting conversation? You kept texting Alex over and over and over, and Alex just didn't respond.
Objection, hearsay.
Sustained.
Okay. You continued to text Alex. Okay. I want to talk to you about April the 7th. That is a day that you had come down to the DA's office to visit with them about the incident and also to visit with them about some of the details you're providing. Do you remember that day? Yes.
Yes.
Do you remember who you met with?
So, Sarah, there's somebody else I've spoken with. That's a part of the team. There's 3 women.
And do you remember how many people were there?
3 women.
Okay. And the purpose of that visit was to go over the incident with you, correct?
Yes.
And they also were asking you questions, maybe seeking information they didn't already have or details they didn't already know about, and they were asking you. Do you recall that?
Yes.
Now, we've already talked about the SD card. I believe that you testified that you remember the SD card coming up in that conversation, and you were quite clear with them. The only reason there's not a video recording was because there was no SD card.
Objection as an answer.
Sustained.
Okay. Do you recall there being a discussion about the SD card?
Objection as an answer.
Overruled.
Yeah.
Yes.
You can answer.
I said that there was a possibility that I would actually get you to a tree or something, but I'm so long with that camera and the SD card specifically and that effective camera, there has not been one since January 1st, as I had stated previously.
All right. With regard to any potential audio recordings, do you recall that discussion happening?
With SD cards, we carry so much storage. Trying to go back months prior, it's it overwrites itself.
Okay, and I want to be very, very specific. And my very, very specific question is this, Ms. Wise. Did you tell the prosecutors and the advocate on April the 7th, when you were meeting with them about the details of this incident, that you had an audio recording of the incident?
Objection as an answer.
That'll be overruled.
To say yes, it was a possibility. I will check it. I was not able to check it, so.
Okay, so your memory is you told the prosecutors you might have an audio recording.
Yes,
Okay. With regard to these videos that we're talking about, how many cameras were in your apartment that could have recorded or gathered audio or visual information?
one that would be able to review it going back would be the living room back. The first, if camera in our bedroom, you cannot pull up any previous storage on that one. You have to look at it from a live view of the AV monitor.
Okay. There are two cameras in your apartment, correct?
Yes, sir.
And the cameras are linked to an app, correct?
Yes, sir.
And the only person that had the app or access to the app is you.
Yes, sir.
And so, sort of like a Ring camera. Now, these are not Ring cameras, but sort of like a Ring camera. They send videos to your phone, correct?
If I try to like review it, nothing gets sent to me. I can pull back up though.
Right.
After so much time though, you cannot. It's the SD card is the limited space.
Understood. And the person that has complete control and access to all of the content, audio or video is you.
Yes, sir.
All right. Alex didn't have any control of any of that, did he?
No, he never asked for the loan.
Okay, Your Honor, for now, that's all the questions I have. I'll pass the witness.
Just a few more questions, Your Honor. Ms. White, why are we here today?
Alex punched me in the face and that was a violation of his building.
Okay, can you identify, is the defendant here present in this courtroom today?
This is,
Can you please point him out by clothing?
is there gonna be a strict, collar photo at the table? That's decision.
Okay, thank you. Let the record reflect that the complainant has recognized the defendant. Ms. Weiss, do you still fear the defendant? And why is it important to you that the court or the defendant is held accountable for what he did?
Judge, I'm gonna object. This is not relevant.
Sustained.
Okay. No more further questions, Your Honor.
Any further
No,
questions?
no additional questions, Judge.
Is this witness excused?
Yes, Your Honor.
I mean, I would say for now, if we could keep her around, Judge, I might have to recall her. I'm
Right,
sorry.
if you'll keep the witness available today for recall. State, call your next witness.
With the state rests, Your Honor.
Defense, any witnesses?
Yes, Judge. Judge, can we approach briefly?
Yes.
So, after hearing some of the direct testimony, I would need to be calling her as a witness. Brief conversation about that. My understanding is that her advocate, Sarah, was also there, and she informed me that I could utilize her if I needed to call her.
Who do you want to call?
It, it honestly does not matter to me.
No, I mean,
The advocate.
whoever you want to call.
You have to go to the proper channels of opinion.
This is a rebuttal witness, Judge. This did
No, who do you want to call?
Sarah.
Who is the Sarah person?
Yeah, okay.
All right, can you have Sarah come down?
Well, Judge, I was here informed that she be made available to me as well.
Proper channels still to be followed. Your Honor, he needs to subpoena Sarah if he wants her down in court.
All right, did y'all tell him that that she would be available?
Yes.
Not a party to that
All right.
conversation.
Have Sarah come down to court. And if somebody from the appellate section wants to file a motion that she should not be allowed to testify, then y'all can do that. But tell Sarah she needs to come down.
I'm texting right now.
All right, thank you. Anyone else you want to call other than Sarah? Did you want to call Ms. Jones as well?
I don't believe that I will have to, Judge, so no.
And where is Ms. Jones?
I believe she's upstairs too.
Have Ms. Jones come down as well.
Yes, Your Honor, text them both.
All right, and then we're going to take a short recess from this and I'm going to take up other matters.
Yes, Judge.
Thank you. Eddie Baldwin.
Yeah.
All right, and after Eddie Baldwin, then I'll take up the matters on the parties who are here for trial.
Hello, Your Honor.
Hello, how are you doing?
I'm doing good.
Wait a minute, let me put on my glasses. Is that SpongeBob?
Yes, it is.
Oh, there's a rumor. And I think the facts will bear this out. That the Krabby Patties are made from crabs. Oh. And that's why you don't see any crabs in SpongeBob's world, in Bikini Bottom. Have you ever seen a crab in Bikini Bottom? Except for the crab patties?
Mr. Krabs.
Mr. Krabs.
Mr. Krabs is
That's
killing.
what he guards that
Oh, so
recipe.
He does.
You got
That's right.
something there.
Yeah.
What? That's a really.
Sorry. You know, all evidence points towards that. And don't get me started with the squirrel. I mean, everybody just was fine with her putting on her helmet going down there. But okay. I like SpongeBob,
Thank you.
but now that song is gonna be in my head. All right, the court is calling 2026 CR 0000656-02, State versus Eddie Baldwin. Can I have parties announced?
Lauren Espinoza for the state.
And Valerie Headland for Mr. Baldwin.
I'm so sorry, you're gonna have to take that to the court, yeah.
Oh, yeah.
And are you Mr. Baldwin?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Baldwin, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes.
State, are you proceeding on the indictment as presented?
I do believe so, Judge, yes.
Mr. Baldwin, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, to charge with the offense of robbery, that's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call on the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Baldwin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There's $1,000 fine probated. The state recommends community supervision. They're taking in consideration 2025 CC 016045. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both
Yes,
places?
ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 100 hours of community service restitution, no contact with Judy Apolinar or any Cricket Wireless in Bear County, MRT, and the felony theft course. Did you understand those are recommendations from the state,
Yes,
and
ma'am.
the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers States Exhibit 1 in all attachments.
No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
No, Judge, he was in custody for quite a few minutes
Yes,
before
ma'am.
you pointed out. So I think he's had plenty of time to reflect, and I think he's gonna do well on probation.
Why did you do this?
I was on drugs. Yes,
Okay.
ma'am.
So are you living with someone? Do you live by yourself?
I live with my mom.
Okay. Do you have any children?
I got one, a
Right.
son. Yes,
And
ma'am. He's
age?
5 years old.
Okay. How far did you go in school?
I made it to the 10th grade.
Okay. Have you obtained a GED or
No,
anything?
ma'am.
When's the last time you had employment?
I'm employed right now, but before I got locked up at this time, I was with UPS. And then when I got with them, I got locked up and they fired me. So as soon as I got out, I started working with my brother doing general labor, and I've been with him ever since.
All right. And I'm assuming UPS is not gonna hire you again?
Ma'am.
Okay. All right. The court is gonna sentence you to 4 years in the prison, suspended and probated for 4 years. There's regular reporting by Zoom or in person,
Yes, ma'am.
regular random UAs, proof of employment within 40 days, no employment as a home health care provider or minors, and what drugs were you addicted to?
I was on methamphetamine.
Okay,
Yes, ma'am.
all right, we'll do a referral to felony drug court. And that can be out of custody. And if not accepted to felony drug court, then do a TAP evaluation out of custody, follow recommendations, but if they recommend inpatient treatment, we'll start with outpatient treatment. Taking consideration 2025 CC 016045. There is $1,000 fine, probated. No contact with Judy Apolinar. Do you have service with Cricket?
No, ma'am.
All right. Is there any need to ban him from all crickets? Do you have a cell phone?
Yes, ma'am.
Who is it? What's the,
Metro PCS.
all right. All right, there's to be no contact with the cricket at that location.
Yes, ma'am.
And that is, let me see.
Address if needed, Judge.
Hmm?
I can provide the address if needed.
Oh, yes, please.
2118 South Zarzamora, number 450.
You said number 450?
Yes, ma'am.
Do you have the zip? Is it 78201?
One.
All right,
probably.
Yes.
78201. So you're not to go to that cricket, okay?
Yes, ma'am.
There's gonna be 100 hours community service restitution. And 25 hours will be deducted. I'm sorry, not 25, 50 hours will be deducted if you obtain your GED or some type of trade school certification.
Yes, ma'am.
The remaining hours will be deducted at 1 hour per completion of sober support meeting. Field visits 1 time per month for 8 months. And are you gonna remain living with your mom?
No, ma'am.
Okay. Make sure that you provide stable housing to probation. If there's an issue with stable housing, you need to let them know about it.
Yes, ma'am.
The felony drug court will be really great for you because they can help you with that.
Yes, ma'am.
And then you could see a lot of people stay at Tiny Village in San Antonio. I think it's called Twin Towers or Tiny Twin, something of that nature, but you can Google it. All right. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No,
All right. If you need anything, be sure to let probation know and just be honest with felony drug court, because I think that would be a good placement for you.
Yes, ma'am.
All righty, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to your attorney, okay?
Yes, ma'am.
And it's called Town Twin Village.
Yes, ma'am.
And at the Town Twin Village, you may not be in the age category because they have certain restrictions. And I think it's sort of like people in their fifties. However, they do have a place where people are homeless.
With their
You can get
children.
laundry, your laundry done,
Yes, ma'am.
you can take a shower. And I think they allow you 10 minutes, which other places, they tell me only allow 5.
Yes, ma'am.
And they provide meals, 3 meals a day.
Yes,
Okay.
ma'am. Yes, ma'am.
All righty. All right, well, good luck to you.
Thank you so much.
You're welcome. Have a good one and just stay in touch with probation, okay?
Yes,
That's what
ma'am.
I told him, that that's the worst thing you can do is just fall off the radar, so.
And trust me, those are crabs in those crab cages.
Yes, ma'am.
All
Maybe
right.
being like he's-
Okay.
Okay.
Like that.
All righty. On Joshua Sutherland. All right. Oh, come forward, yes. All right, so you all are up for trial.
We're ready, Your Honor.
So, all right, so I'll need y'all here tomorrow at 9 a.m. because this hearing is taking longer than anticipated.
Okay.
So Ms. Ferguson will give you a reset.
Okay, thank you.
Thank you. Marcos Rios.
Present, Your Honor.
All right, council, I'm gonna need you all back tomorrow at 9 a.m. A jury should, I held on to this jury, so they'll be back at 9.
Okay.
Yes.
We don't sign anything, do we?
No, your client is in custody.
No.
Okay, so yes, you'll need to sign a reset.
Okay.
All right, and then Ray Cordova.
I don't think defense counsel ever showed up.
All right,
Bridget Garza?
Norma. Yeah, I know. With that one, is she gonna be available anytime this week? All right, recall him for next week. The defense attorney had an emergency.
Oh, understood.
What date? All right, so Mr. Cordova, don't leave until you sign the reset form. Jesus Suarez Marino, that's gonna be tomorrow at 9, and Norma, he needs to be brought over dressed.
He's on there. He's,
Oh, he's on bond?
he's just
all
not
right.
a reset form.
All right, just sign the reset form.
Yeah.
Jesus Alanis Zarate,
He's in custody, Judge.
all
Ready.
right. I'm gonna have y'all come back at 9. This hearing is taking longer than anticipated. So I'm expecting the jurors to be up here tomorrow at 9, all of the jurors, because I'm just recalling them to come back.
Okay.
So we should be ready to go at 9.
That's wrong.
Thank you.
There. Sorry.
Andre Middlebooks.
It's already reset, Your Honor.
Okay, thank you.
To Ju-
Oh, June 16th.
Yes, Your Honor.
Jonathan Pomerantz, See you tomorrow at 9 a.m. Nicholas Vaquera, 9 a.m.
See ya. He needs to sign a receipt form. He's out.
All right, thank you. Michael Balderas, tomorrow at 9 a.m., and that's number 1. Robert Porter,
I'm here, Judge.
hi. All right, Mr. Porter, on your case, we'll recall you all back tomorrow. Let's see, but y'all are not number 1. There's another
My
case.
wife, you could call me number 2. Oh.
Well, wait a minute. Does that include all of the, happens?
Oh.
Yeah. Because Robert, with my mom, I've fallen. And Norma, let me know when you're ready for the next. Have you finished with page 2? No, I haven't done that yet. They need to confer. All right, on number 3, Balderas, that's tomorrow at 9. Hilliard is at 9 tomorrow. McCormick, we've already done that. Timmons is done. Merritt. All right, so we're still gonna be taking that up. Yeah. Sure. And Deputy Laura and Deputy Mejia, if you can have Courtney Price brought out.
Welcome.
Yeah.
Dollar. Okay, and dollar. See.
All right, Arojo, that attorney needs to be here. All right, let me look at that a little bit later. Okay. And what is happening, all right, Norma, that is it. Okay. All right, Reyes, all right, the court is calling 2026 CR 0000976 State versus Isaias Reyes. I'm sorry.
Sorry, good, Your Honor.
All right, could I have parties announced?
Lauren Espinoza for the state.
Robert Farron from Mr. Reyes.
And are you Mr. Reyes?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Reyes, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Reyes, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,000 fine probated. State recommends deferred adjudication. This run concurrent with 2025 PF 37473. Did you understand that to be your plea?
Yes, Your Honor.
Defense of the state.
Yes, Judge.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be 120 hours of community service restitution. No contact with 12280 State Highway 16 South, San Antonio, Texas 78224, MRT and the DOEP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments, and also regarding that PF number, I have the filed CC number for
All
the
right.
court.
Yes, and what is that number?
2026 CC 006893.
Any objection to the court writing that in the plea?
Okay.
All right, so you say 226 CC 006893?
Yes, Judge. Thank you.
You're welcome. All right, and then state you're offering into evidence
State's Exhibit 1 in all attachments, Judge.
and no objections?
No, Judge.
All right, state you may be excused.
Thank you.
Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client? So this location, what's the name of this location?
It's for flea market.
Okay, because they were talking about a dance floor. Is there,
This one.
oh, so it's the dance They have dance.
Yeah, it's like a flea market where everybody goes and like they got like their own dance floors.
Okay, because I was trying to, because I didn't see the name. So what else do they have at this flea market other than the dancing?
I just could go shopping by like clothes or food.
All right, and what time is this alleged to have happened? Was it during the day or?
I really do not remember, Your Honor.
Okay. So this is a possession less than a gram case. If you're drug tested today, what would the results be?
Negative.
Why does it take you a long time to say that? So here's the thing, I need you to tell me the truth because I can tell you right now, I'm gonna follow your agreement, but your attorney will tell you, I'm trying to give you conditions that are gonna help you. So if you're gonna be positive, let me know because they're gonna drug test you.
No, Your Honor, I won't be positive.
If you even think you're positive, it's okay to say so.
No, yeah, I understand, but I'm positive that it's gonna become negative.
I'm sorry, what?
I'm positive it's gonna come out negative.
Oh, okay. So when's the last time you used?
Believe like it's been a month or so. Cause I was out of state working,
Okay, and do you, oh, what do you do?
construction.
Do you have any children?
No, man.
So state, with regards to this no contact, he's telling me that location is a flea market.
Yes, Judge.
Do y'all have any objection to him having contact during the daytime? I don't know what time this dance happened.
So the report time, Judge, was 15:33, which would be, what is that, afternoon
Three,
time,
yes,
3
3
PM.
So,
But whatever the court sees fit is fine.
well, I can do you can have contact with that location, because I know with the flea market, sometimes people go there to buy things. But it'll be from, what time does the flea market open?
Like around 9 in the morning.
9? So it will, I'll say like from 9 to 12, you can have contact, okay? But don't go to the dance floor.
Understand, Your Honor.
All right. Okay. This is what the court is gonna do. There's $1,000 fine, probated, concurrent with 2025 PF 37473, which is the same cause number as 2026 CC 006893. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. And with regard to the regular random UAs, he can do that or do the patch. Sometimes the patch doesn't work well if you're working in construction because of the heat. Your attorney can explain to you about that. There's 120 hours community service restitution. I'm gonna order the DOEP course. Once that's completed, 60 hours will be deemed satisfied. The remaining 60 hours, there will be an hour deducted for every completion of the sober support meeting. There's allowed contact Monday through Sunday. Well, I'm sorry, I'm just gonna say daily contact from 9 AM to 12 PM at 12280 State Highway 16 South, San Antonio, Texas 78224. There's a TAP evaluation out of custody. Follow Rex. But if it says inpatient treatment, start with supportive outpatient treatment. Probation, is there anything else?
For those hours that you can't enter that location, I mean, that it's allowed to enter, can you give me those hours one more time?
9 AM to 12 PM.
And field visit,
We'll do field visits one time per month for 3 months.
nothing else, Judge.
All right, is there anything else that you need from the court to be successful?
Sorry, Your Honor.
Did you, and I'm sorry, no possession of firearms? And the reason why I'm doing that is because you have an unlawfully carrying case in misdemeanor court, I'm assuming. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it
Yes,
and
Your
sign
Honor.
it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you, ma'am.
Thank you. You're welcome. Let's see. Courtney Price.
Saying whenever it is, just make sure you're on.
Hello. How are you doing today?
I'm well.
All right, so, I'm sorry?
My attorney is in here.
No, he's out of the country,
Oh, okay.
so. But state, you have the discovery on medicals?
Yes, those are in, and those have been tendered to Mr. Garcia.
All right, so, and was an offer tendered?
An offer has been tendered, yes, Your Honor.
All right, so Norma, set this for a plea deadline date and a jury trial date mid-May. And, Family Collins, are you all on all of these cases?
Yeah, Judge, DTV has the remaining, Judge.
All right, because,
If I may suggest, Your Honor, there's like a hybrid family violence litigation trial we can lay on May 26th. We have that.
yes. Who's calling me? All right, Norma, they're asking for May 26th. All right, so we're gonna bring you back on May 26th, okay? Your attorney will be back here well before then to speak with you. And if he has any issues about that date, then the court will take that under consideration. All right, do you have any questions about anything?
No, Your Honor.
All right, thank you. Yes, trial date and plea deadline date. All right, where are they on this case? All right, they need an interpreter. All right, what is happening with Toshi's case? What's happening with this case? Is the prosecutor coming down? Who's coming down? Nobody's coming down?
I think this is wrong.
You know, I'm just cool. I don't. Just.
So, I'm sorry, Jeff.
So now we have 4 state's attorneys here. Well, let me see, 1, 2, 3, 4. 4 state's attorney, but Ashley has disappeared, so now we're with 3. Ashley is upstairs, even though according to you, Mr. Toshi, that Ashley or the advocate said they will be available if you needed to call them. And so instead of them coming down as I instructed, we have 2 attorneys that are not either of the people that you wanted brought down. So what's going on?
So
I just like to do a synopsis for my mental.
this is
Yes.
definitely not Ashley or Sarah. But you know, we're glad they're here. What we have been discussing is.
This is not on the record, right, Judge?
No, it's just how are we going to proceed? That's all I need to
I
know.
think ultimately we're gonna have a stipulation report about some.
All right, then
rather than-
let's get the stipulation ready so we can continue.
Okay.
Thank you. See how I just cut through all the
Yeah.
extra sentences?
That's what we need is,
Yeah. Are you still riding your bike?
when I can, actually, I need to leave really soon to get my kids, so
Ah,
I'm gonna
okay.
try to wrap this up with a nice bow for you.
Thank you. I appreciate that. Who's next? What page? Melinda Gonzalez. Hello, good morning.
Joseph Acevedo Jr. here for Joseph Acevedo.
Thank you.
All right, brother. Thanks.
So if I may, we're actually just hired on this case this morning, and so we're asking for a reset. So we can go over everything with Ms. Gonzalez.
Okay, just 1 second. Let me see how long this has been on the docket.
This might be her first studying for this MTR. I think from my understanding is correct, she's bench warranted from the other counties.
All right, Norma. Set this in 10 days for a contested hearing. All right, y'all need to be back here May 7th, contested.
So,
All right, thank you.
Thank you, Judge.
You're welcome. Who's next? All right, who's here on Ethan Castillo? Oh, you still conferring?
Yes, please.
All right, Jeffrey Dollar. All right, Arojo. If you'll come forward. Norma, on Arojo, you said he broke his ankle or something? All right, so your attorney has a broken ankle. As we get older, things just happen. You take a step down the stairway, you don't hit it just right, you break an ankle. And that's just what happens to men. Women, we're okay.
All right.
Yeah.
He's all right though?
Oh, he's okay. I mean, except for a broken ankle. He's okay. I think he's gonna be okay. You know, I always tease people and say, now, if a woman had broken her ankle, let's say if a woman had broken her ankle at 2:30 today, she would already be back at work. So a guy, he breaks his ankle, it's like, I need to be out for 2 years for it to heal. So, we're gonna recall you for a plea deadline date. Norma, put this for a plea deadline date at the end of May, please. All right, does that? Does the 26th work for you?
Yes, ma'am.
Are you employed?
Yes, ma'am.
Is that gonna interfere with your employment or that gives you enough time?
It is, ma'am, but y'all close before 5 break.
Well, no, I mean, I'm here till 5.
It is, ma'am, but I'll have to.
Right, well, I mean, if you want to appear by Zoom, you can appear by Zoom.
Oh, if I can do that, ma'am, that'd be great.
All right, Norma, he can appear by Zoom. All right, once you sign the reset form, you excuse. Thank you. Thank you for addressing appropriately for
Yes,
court.
ma'am. You have a good day.
You too. Did the jury get released, Judge? Oh, they'll be back tomorrow. I just didn't know if they got released. Until tomorrow. Until tomorrow.
So apparently there's a guy that's been
Utopia.
sitting here all morning in the one.
Trades going on in there.
That Godfather.
Now, I
Thank you.
watched The Godfather, but I can only watch it once because it's too
Violent?
violent, realistic
What-
violence, right? For
What is,
example,
what is the co-
I'll watch The Boys.
What- what's the
Because,
cause number?
yeah,
Like,
'cause I like I like Soldier Boy because
Are they
I love Supernatural.
I've heard they got great reviews.
Oh, it's excellent, and I'll watch Invincible.
0-0?
So, but I don't
3-0-6-1.
watch it.
Top one.
Hmm?
You wouldn't like that then?
Yeah, I don't like realistic violence.
Yeah.
Because I know everybody thought, what was the movie? It was with Al Pacino. I think it was Al Pacino.
Scarface.
No, not Scarface, although I found that very bothersome. It was the one with, what is her name? She played in Basic Instinct, Sharon Stone. You remember Sharon Stone and Joe Pesci?
Goodfellas.
Yes, that.
Yeah.
I can't, when they took them out to the cornfield or wherever, I was just like, oh, I can't watch this.
Drunk, yeah, I agree with you, actually. I don't like that.
Mhm.
All right, thank you.
Sure,
Appreciate you.
who's ready? For which case? All right, it keeps saying that it's getting my case. Yes. All right, Goose One.
Good afternoon, Judge.
Good afternoon, how's it going?
Good, and you, how are you?
Hey, it's turning into a Monday. I think because it was Fiesta, I think this whole week is gonna be a Monday. Usually if you just have vacation, on a Friday or something, you're like, oh, Monday's gonna be a Monday and whatever date it is. Yeah, I'm
Okay.
sorry, I'm just waiting for,
Right to work.
I see. Yeah.
Okay. One thing to-
Hello. Hola.
Hola.
¿Cómo está?
Muy bien, yo sé.
Whenever I'm traveling, sometimes I forget and I'm in Paris and I'm speaking sort of Spanish because it's sort of similar. And then I'm like, wait a minute, I don't think I'm saying that correctly. Okay. Oh, so are you ready?
Ready.
All right, today is the plea deadline date.
Okay, Judge.
So have you all come to an agreement or is this going to be a jury trial?
No, Judge, we actually like to get a short continuance. I've been talking to the state and there's some underlying issues that we want to talk about. And also the possibility of maybe filing a motion to suppress. And so this case, I just don't want to say too much.
Yeah.
But there is something that it's underlying this case is the co-defendant that we need to try to.
So
figure
are you
out.
all going to have a motion to suppress? Is it going to be dispositive or not?
I think so, Judge, yes. But there's the other issue too, that is.
All right, Norma. Set this for the week of. You know what, Norma? Just set this on. Just 1 second. Make sure, okay. Norma, can you set this for a motion to suppress on May 20th? Are we here? Yes. All right, motion to suppress and plea deadline date is May 20th.
Wait. Okay, Judge.
All right, is there anything else?
Nothing else.
No.
Anything else?
That's all.
All right, thank you.
So gracias.
Bye.
Thank you.
De nada.
Maybe excuse.
Yes, thank
Thank
you.
you, Judge.
All right,
Thank
you
you.
two have a good one. All right, Ledesma.
There you are.
And then after this, I think they're ready on the contested. Court is calling 2022 CR 6907B State versus Isaiah Ledesma. Could I have parties announced for the record?
Lauren Espinoza for the state.
Robert Porter for Mr. Ledesma.
And are you Mr. Ledesma?
Yes, ma'am.
All right, Mr. Porter has been appointed to represent you, and he was just appointed to represent you today. Your attorney does have certain rights, or I should say you have certain rights through your attorney, and one of them is notice and a chance to prepare. So I can reset this case so your attorney will have more time, or we can proceed today. Which would you prefer?
See today.
All right, and
Okay.
defense? Okay. All right, Mr. Ledesma, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Isaiah Roman Ledesma who was placed on deferred adjudication in 2022 CR 6907B for the offense of robbery on October 18, 2022 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bear County, Texas. The defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the month of December 2022 in violation of condition number 4.
I just want to make sure, Judge, that's going to be on the First Amendment.
Oh, it's the First Amendment?
Yes, Judge.
All right, I don't have the First Amendment. All right, did you review the First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
All right, state, you may continue.
Okay, violated condition number 4 in Bear County, Texas. The defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the month of January 2023 in violation of condition number 4.
All right, how do you plead to that, true or not true?
True.
Violated condition number 4 in Bear County, Texas. The defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the months of February, March, April, May, June, July, August, September, October, November, and December 2023 in violation of condition number 4.
How do you plead to that, true or not true?
True.
Finally, violated condition number 4 in Bear County, Texas. The defendant Isaiah Roman Ledesma did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, and October 2024 in violation of condition number 4.
How do you plead to that, true or not true?
True.
State will waive the remaining allegations.
All right, and that's a violation of number 4, is that correct?
Correct.
All right, any objection to the waivers?
No, Judge.
Did you understand by pleading true to those violations, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4, 4, 4, and 4?
Yes.
Court will find 4, 4, 4, and 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke supervision, and sentence to 6 years TDC to run concurrent with Guadalupe County cause number CCL 250532.
Is that the agreement?
That is right, Judge.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, so I have a question. Probation. It says that there is to be restitution to Isaiah Miramontes. Was there any restitution ever ordered?
No, Judge.
Okay. All right, this is what the court would do. The court is going to find you guilty, grant the motion, sentence you to 6 years in the prison. This will run a concurrent with Guadalupe County County cause number CCL 250532. There's to be no contact with Malik Lampkin, Jennifer Trevino, or Isaiah Miramontes. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Make better choices.
Judge,
Yes.
one thing I just wanted to make clear,
Mhm.
and I think the clerk has already changed that. This MTR was,
Just 1 second. Cindy, we're still on the record.
Okay.
Go ahead.
this MTR was filed, the amended one in May. He'd been in Guadalupe County for some 15 months already.
Mhm.
Jail, and when he took his plea, it was on his accord that he actually wrote the district attorney's office a letter saying, hey, can we do something about this? I wanted to make sure he was gonna get the credit for the 15 months that he had sat in the jail under this case. You know, that the numbers we're talking about over here.
Okay, so let me ask you. The original motion to revoke, not the amended, when he was in custody, had that already been filed or no?
The original one was filed back in.
I'm trying to look it up.
26.
It was February 28th, 2023,
Okay, and so February 8th, when?
of 2023.
All right, and so when was he in Guadalupe?
Then he got picked up in November 2024. And
Yes.
since from 2024 to present, he has been incarcerated.
So yes, he'll receive all that time.
Thank you, Judge.
All right, and they'll just make sure that the clerks have it correctly. If for some reason, when you're transported, you'll see what your time is. If for some reason you feel like it's not correct, just let us know, and it'll be easily corrected, but the clerk should know how much time. And counsel, once they do the judgment, if you want to bring it back to me if you have any issues. And so we'll be able to know, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am. Thank you.
All right, you're welcome. Good luck to you. All right, are you all ready on this Mia sick?
We are, Judge. Or real quickly, I didn't realize that I have had a client here all day long. They missed my calendars. It's here in court.
Okay.
Can he be reset? Julio Salazar is his name, Judge. I put him on the list. Was unaware that he's been here all day. Kind of feel bad.
Oh, okay. All right, Mr. Salazar, if you could come forward. Okay. Hi, how are you doing? All right. Sometimes mistakes happen. It's not a choice. Sometimes it is a mistake. So we're gonna recall you back. All right. Are you employed?
Yes, ma'am. I have my own payment company. Ma'am.
So if we call you back. Are you okay, Cindy?
Yeah.
May 25th, that's a holiday. How about the week of May 18th?
Did we go a little later than that, Judge? That is a poor week for me. You're asking.
All right. We'll put it on the 28th. Norma, recall him for May 28th. All right, thank you.
Thank you, Judge. I'm sorry about that.
Once you sign the reset form, you'll be excused, okay? You're welcome. All right. We're gonna go back on the record in 2024 CR 3533, State versus Alex Miosek. Could I have parties re-announced for the record?
James, don't you please?
Oh, your client needs to be.
Yes, ma'am.
All right, Mr. Toshi, call your witness.
Judge, before I do, while we were on break, there was an issue regarding one of the DA employees testifying. I've conferred with the state and we have an agreed stipulated item of evidence I'd like to offer to the court. It's identified as defendants 3, and I'll share with the state right now.
All right, so to the state's attorney, did the other male attorneys who came down here, did they go over that stipulation with you before?
Yes, Judge.
Okay.
We'd like to offer defendants 3 into evidence, Judge.
All right, any objection to state's exhibit number 3?
No, Your Honor, we did talk to the defense and we informed him that if he wanted to have the advocate or the other witness here, he had to go to the proper channels of subpoenaing the witnesses, and we agreed to that stipulation, Your Honor.
All right, so I'm gonna let the record reflect, and if anything that I'm putting on the record is improper or misheard by the court, let me know. My recollection is that Ashley Jones, is that her last name?
Yes, Your Honor.
Yes, Judge.
Ashley Jones, the first year prosecutor, was down in this court assisting with this motion to revoke. The advocate was brought down with her. There was a conversation. I was in the room with the conversation. Mr. Toshi was here. The prosecutor was here. And my understanding from Mr. Toshi is that either Ms. Jones or the advocate would have been made available for him to call as a witness if he chose to call them as a witness. Is that correct? Yes or no? If it's not, tell me.
It is more or less. I had a conversation with Ms. Jones after we broke, and I told her I'm going to need her to testify. She had indicated her desire not to testify, and I explained the reasons why, and she had informed me, the advocate was there. If you need to, you can call the advocate. Now, I don't know if she was being tongue-in-cheek with me, but that was
tongue-in-cheek in the middle of
well,
a hearing.
we're off the record and just,
Yeah.
and so I did communicate via text on the break. Please have the advocate available. I'm going to need to have somebody testify, anticipating these issues would occur. I did confer with several representatives of the DA's office and my client. I'm comfortable with the stipulations we have here, and the information is now before the court.
All right, and so, and where is Ms. Jones?
And she's currently not here, Your Honor.
So we start hearings, but we don't finish them. Okay. All right. So, Mr. Miosek,
Yes, ma'am.
if you can come forward. According to the law, your attorney has the right to at least attempt to have witnesses here that he would like to have here in your defense, or just witnesses he feel to call. So 2 of the witnesses he wanted to call, or either one of them, was either the prosecutor, Ashley Jones, or either the advocate. And what's the advocate's name?
Sarah Herrera, Judge.
Sarah Herrera. Now, he is informing the court that the state, with 2 male attorneys that they brought down who were not a part of the hearing, but they brought them down, have decided to stipulate to certain testimony. So what that means that your attorney is no longer seeking to have witness Sarah Herrera or Ashley Jones called as witnesses, where he would have a chance to question them, and the state would have the chance to cross-examine them if they so choose. He's decided just to accept this stipulation. The state is saying that they're not going to object to this stipulation, so no one is going to have a chance to question this witness, which is the victim advocate, Sarah Herrera. So the question is, do you have any objections proceeding with just this stipulation and not having the witness brought down here to be questioned by either your attorney or the state's attorney?
I mean, I would feel like if there's a witness to it, I would want them present.
You want to speak with your attorney?
Well, I mean, we have had a conversation about this. I did inform him of the stipulation.
Well, let's do this. Y'all can place whatever you want to place on the record. Then defense, you're offering the stipulated evidence that is defense exhibit number 3,
Yes, ma'am.
and no objections?
No objections, Your Honor.
All right. Thank you. If you could give that to the court reporter, I've read it.
Yes, ma'am.
Then defense exhibit 3 will be admitted into evidence, and you all may take your seats. Mr. Toshi, call your next witness.
Judge, I'd like for Mr. Myasek to take the stand.
All right, if you'll take the witness. All right, if you can raise your right hand. You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God. All right, you can lower your hand. Please keep your voice up so that I can hear and everyone else can. State your name for the record. All right, defense, you may proceed.
Thank you very much. Alex, can you spell your last name for the record, please?
MIOSSEC.
Okay. All right, Alex, let's just kind of cut right into this thing. Obviously, we've been here for a while and we've already heard from Ms. Wise. I want to just go right to the day, February the 8th. Do you recall that day?
Sure.
And do me a favor, Alex, can you speak a little bit louder? I'm having a little hard time hearing that. Okay. Just to give a little bit of background, where did that night begin? Where were you and who were you with?
We were at a coworker of mine's birthday party celebration. It was at their apartment complex.
All right. How many people were you with?
Probably 50 or more at one point.
All right. towards the end of the night, did the group of 50 kind of whittle down into a smaller group?
Yes, from there, it's probably like 5 or 6 of us, maybe.
Okay. And were you with Olivia Wise?
Yes.
All right. That night, let's kind of pick up from about midnight on. Where were you?
We were at Camp 1604 in Kung Fu, kind of popping around. There are 2 bars that are right next to each other.
Okay. In your estimation, kind of what was the mood of the group that was there, including yourself?
Yeah, it was good. Everything was going good for the most part. Say Olivia was, at one point, she was a little cranky about not being able to find me because I was socializing. I kind of got over that, and then she kind of turned into the mood of, she was kind of in the mood of having sex and stuff later on.
Okay, well, we'll get to that here in a second. Had Olivia been drinking?
Yes.
Okay, a little or a lot?
I guess I would say a fair amount.
Okay,
I wasn't counting.
sure. She wasn't like fall down drunk, but did she have a good buzz to your?
She was pretty intoxicated. She was-
Objection, Your Honor, speculation.
All right, that'll be sustained as to speculation, if you can lay the foundation.
Well, I mean, how many drinks would you say she had?
We had been there for hours, so say about 3-4 hours.
Objection,
worth of drink.
speculation.
Overruled.
Go ahead, Alex.
Yeah, I'd say about 3 or 4 hours worth of drinking from where we were before to when we ended up at the bar.
All right. Now you mentioned, and this has come up and you've been watching, did Olivia want to have relations with you that night? Did she want to have intercourse?
Objection, hearsay.
Of course.
All right, so here's the thing, when objections are raised, you need to stop talking so I can rule on them. Ask your question, please.
Did Olivia wish to have intercourse that night?
Yes.
Objection, here.
Sustain.
Judge, I'm not asking for a hearsay response.
The objection is sustained.
Okay. Without telling me anything Olivia may have said, what gave you the impression she wanted to have sex?
She texted.
Objection, speculation.
With regard to speculation, that'll be overruled.
Okay. And she's already told us about the text message. Was her behavior consistent with what she was texting you?
Yes and no. She was going back and forth between being a little kind of wanting to have an altercation, but then she would go back to being back in the mood.
Okay. What time was it that you guys left the bar you were at?
I would say closing time.
And when I say you guys, I mean you and Olivia. You were there together, correct?
Yes, sir.
When you, what time do you think it was when you got home?
3-ish, I would say. It's
How-
a good 45-minute drive home.
Okay. Olivia doesn't live in Bear County?
No.
Okay. Let's kind of pick up there. Now you're home. You guys have been out at a bar. What kind of transpired once we're home and settling in?
Well, I was already getting ready for bed. I was already laying down in bed. And I was kind of on my phone when we first did get there, though. She was obviously in the mood. So she was kind of grinding on me, telling me what she wanted to do. I was laying down in bed, I was on my phone. That caused her a little bit of frustration. Because her words were, you care more about your friends than, me trying to sleep with you right now.
Okay. So when you got home, Olivia was interested in sex. Were you?
Wasn't against it.
Okay. And where were you? Like where was this taking place?
I was laying down in bed on my side of the bed.
What were you wearing?
I think I was just in my boxers, honestly.
Okay. Do you recall what Olivia was wearing?
One piece.
One.
Felt like a one piece, like not lingerie, but just like a one piece.
Okay.
button up.
Okay. And so let's talk about this critical part. Like, how did we go from that to this incident? Like what did Olivia, what do you recall Olivia doing?
Well, she was frustrated because I wasn't really paying attention to her, so she got up, went to go get water. She was about at the end of the hallway. I was laying in bed. She just started arguing with me, and words were exchanged between both of us. And she just kind of kept trying to bring up what she wanted to fight about originally, which was pointless. So, and that I did yell back at her that, you know, you'd be a lot cooler if you would just quit your bitching. Like, you know, how about you know, shut up. And I
Okay,
did say that, yes.
okay. Well, I wasn't asking you about anything you said.
Yeah.
Did you ever leave the bed?
No.
All right. So the two of you came together by her coming towards you, is that correct?
Yeah, she jumped off that.
All right. Was she on the bed or was she on you? Like kind of, how was she physically positioned?
She was like hovering over me, like on her knees over me.
Okay.
Not quite on top of me, but like just right over me. And I was laying down on my back.
All right. Did you ever move? Were you just laying there the whole time? Okay. And so did there come a point in time where Olivia started to get physical with you and not a romantic physical, more of a violent physical?
Objection leading.
Yes.
Sustained.
Okay. Well, during this interaction, did Olivia do something?
Yes. She hit me repeatedly in the face.
Okay. With?
Right.
Do you know why?
Because I had said what I said.
Okay. You said something that made her mad.
Yes.
Okay. How many, so is she straddling you? Do you, or
Yeah,
she,
that would be-
and when I say straddle, you know what I mean, right? Like she's on top of you.
She wasn't fully on top.
Okay.
She had one leg on, like one leg over one of my legs.
Okay.
I was laying on my back, so she had her leg over my right.
So she started hitting you
Yes.
with
Her hand.
how many times?
Say probably 4 or 5 times at least.
Okay. Was it with an open hand, a fist? Do you recall?
I do not recall. It didn't feel like she was punching. Yeah.
Okay. Can I approach the witness, Judge?
Yes.
Alex, I'm going to show you what the mark for identification states. I'm sorry. Fence exhibits 4 and 5. You recognize those? All right. How do you recognize those?
That's me in the pictures that I took shortly after the altercation.
When were the pictures taken?
A minute after.
Do they fairly and accurately depict the way you looked on the day of the incident that we're discussing right now? Your Honor, at this time, I'm gonna offer amendments 4 and 5 in. I'll share with the state for inspection and objection.
No objection.
Right. Fence exhibit 4 and 5 are admitted without objection.
Okay, Judge, and I'm just, if it's okay, I'll share with the front, but I'm gonna, just if you can briefly, with regard to the defendants 4 and 5, Alex, what are we looking at there? What injuries do you have?
So right here, there's first one you see is definitely my eye. I was poked in the eye during her hitting me. There's clear red marks on my ear, neck, and handprints across my face.
Okay. What did you do?
I did put my hand up, to kind of like create some distance. It didn't work, so I did try to like pull her off of me, which is where I believe like her shirt got ripped, which that really irritated her even more. So she continued hitting me.
When you, let's back up a little bit. When you say you raised your hand up, I mean, did you make contact with her face?
Not I believe the first time when I put my hand up, I was still continuing getting hit. So I tried to pull her off.
Okay. Did there come a point in time where you used your hand and you did make contact with her?
Yes, the second time after her blouse, whatever she was wearing, had ripped, she continued hitting me, and that's when I kind of put my hand up and sat up to kind of create the distance, and then
Okay. So you made contact with her.
accidentally.
Well, it wasn't on accident. I mean, you're trying to get her off you, right? Okay. And did you notice she was bleeding?
Shortly after she got up, and that's when she pointed out that she was bleeding. Yes.
Okay. Was there anything that she did that you may have found a little odd with regard to the blood that was coming out of her nose?
Well, yeah, I mean, she noticed her nose was bleeding, so she continued to cuss me out, and her exact words were, "Well, since you made me bleed, I'm gonna make you wear it," and she started throwing.
Objection, hearsay.
Sustained.
Okay, don't tell me anything she said. I just want you to tell me what she was doing.
Blowing her blood towards me,
Okay,
like a farmer's blow, like blowing it towards me.
understood. What did you do at this point, Alex?
I told, my exact words were, okay, like, that was an accident. We need to go clean up. And I immediately, when she walked away, I went to the bathroom, I took these pictures, grabbed my shower bag, and I left.
Okay. Once you left the apartment, where were you going?
Going to my mother's house.
Where does she live?
She lives Callahan and Babcock. About 30 minutes.
How far away is that from Miss Wise's apartment?
About 30 minutes. 30-minute drive.
All right. Did you stop anywhere after you left?
I did, yes. I needed to fill up. I was on E, so I stopped at the Quick Trip on 3009 and 35.
Okay. And while you were there, did anything happen?
She showed up. Surprised.
Okay. Now, again, don't mention anything that she said. But what was her demeanor? How was she acting?
Very aggressively. Jumped out of her car directly towards me, got in my face.
All right. Was this a pleasant conversation or was it hostile?
It's very awesome.
Okay. How long did it last?
Maybe a minute or two until pulled the gas pump out, put it back in, and got in my truck.
Okay. At that time, did you inform her where you were going or tell her where you were going?
Yes, I told her I'm going to my mother's house. It's not going home.
Okay. After you got in your car and left, what did she do?
She followed me all the way to my mother's house, pretty much like tailgating me the whole way.
Okay. Now, don't tell me anything your mother may have said, but were you communicating with your mother at this hour?
Yes.
All right. How were you doing that?
I was on the phone with her.
Okay. Were you texting your mother or on the phone or both?
I was on the phone. I was texting.
All right. Did it become apparent to your mother that you were headed home and Olivia was following?
Objection, speculation.
Sustained.
Okay. So Olivia followed you all the way home.
Objection, leading.
Sustained.
When, when you were driving, was there anyone behind you?
Olivia Wise.
All right. And when you got home, who was there with you?
She pulled up right behind me. I parked.
When you got to your mother's house, did you engage Olivia? What did you do?
I parked my truck, actually drove around the apartment complex a few times when my mother came out because I did not want to give her the opportunity to get anywhere near me. My mother was outside of the apartment. I pulled into her area, to her building. I parked, I got out, and I walked towards my mother to go to her apartment.
Do you know if your mother was engaging Olivia in conversation or dialogue or anything?
Objection, speculation.
If he knows, Judge.
Well,
All right, I'm sorry. So once objections are raised, you need to stop talking. Counsel, if you'll re-ask your question, please.
Do you know if your mother engaged Olivia in dialogue or any conversation?
All right, your
Objection.
objection will be overruled.
yes,
Okay. At some point, did Olivia leave?
yes, after they exchanged words.
Now, from the moment this incident took place at about 3 o'clock in the morning on February the 8th, if I have this date right, how many days went by, Alex, before you made any attempt to communicate with Olivia? Do you recall?
The exact number of days, no, but it was a few.
Okay, 4 or 5, 7 or 8.
Give or take, yeah, probably. So,
Now, during this time, was Olivia communicating with you?
yes,
Often? A lot?
Objection leading.
Sustained.
Okay. How often was she communicating with you?
daily.
Okay. Was she sending you a few or several texts? And you were not responding at all? Okay. At some point in time, did you finally reach out to Miss Wise? Okay, and was that for the purpose of your child?
Objection leading.
Sustained.
Sorry. Why did you reach out?
Because she kept blowing up my phone, so I eventually responded. But
Okay. And I think we all know this, but you and Miss Wise do share a child, and you have one other child, is that correct? Okay. During this period of time in the aftermath where she was texting you repeatedly, what was, without telling me the content of any message, but what was the demeanor or the affect of the messages?
from her,
Yes.
she was attacking me.
Was she saying nice things or bad things? All right. Was she threatening you? Did you threaten her back? May I approach a witness?
Yes.
Alex, I'm showing you exhibit marked as defendant's exhibit number 6. Just take a look at it. Tell me if you recognize it.
Yes.
All right. What do you recognize it?
That is sex between her and I.
All right. So are these text communications from Olivia to you and from you to Olivia as well?
Yes.
Judge offered the defendant's exhibit 6 into evidence.
Any objection?
Yes, Your Honor. I'm gonna object this to hearsay.
All right, may I see it, please?
Yes, Judge.
All right, the objection to hearsay? Or should I say the response to hearsay?
I mean, he's authenticated the text messages between him and Miss Wise.
But how's it not hearsay?
Because I'm not offering it for the truth of the matter.
Then what is it being offered for?
State of
All
mind.
right, the objection will be sustained.
At some point, Alex, at some point, did it just become the smart, safe thing to do just to cut off communication with Miss Wise?
Yes.
And when did that happen?
Completely cut off. The day I got arrested. So, the case was completely cut off, but about a week prior to the incident.
Okay. Last thing I want to talk to you about, Alex, is the apartment that Miss Wise lives in. Were you living with her?
That was our house,
Okay, I keep referring to it as an apartment. Is it a house?
the house.
Okay, I'm very sorry about that. That house, does it have recording monitor cameras?
Yeah, everywhere.
How many?
One in the room, living room, driveway, and there's a ring camera in the front door.
Okay. Let's talk about the ones in the house. Where are those located?
In the bedroom,
Was there a camera in the bedroom the day the incident happened?
yes,
Okay. Are you familiar with that camera?
I am.
The day this incident happened, to the best of your knowledge, was that camera working?
was earlier that day, so I'm pretty sure it was working that night as well.
Okay. And how about the camera in the baby's room or whatever? I'm sorry, was it the baby's room?
There's a camera in our bedroom.
Okay. Who has access and control to those cameras?
Yeah.
And how is that done?
He has it all through an app.
Okay. You recall in the aftermath of all of this, her indicating that she had the cameras and a recording of what happened?
Objection leading.
Sustained.
The camera that was in the bedroom that morning, Alex, is there any reason it should not have captured what happened? Okay. And the only person who would have control over it
Objection
is
leading.
Sustained.
who has control over it?
Living,
Who has the ability to delete it?
living.
Who has the ability to memorialize it forever so we can maybe watch it in court? That's all the questions I have for now, Judge. Pass the witness.
State.
Thank you, Judge.
Hmm.
Mr. Miosek, you're currently on probation, right? And you were placed on probation on November 24. Is that right? On the 14th of November 2024, is that right? You were placed on probation for 2 years. And why were you placed on probation? Okay. And yes, and did you go over the conditions with the CSO? Did you sign a form acknowledging your conditions? And were you aware that you were not supposed to commit an offense in the state of Texas or in the United States? Okay. And do you currently have an offense in Guadalupe County for the offense of assault? Is that a yes or no?
I've only been dealing with Bear County.
But you got arrested, is that right?
Bear County.
Not in Guadalupe County? Okay. But you were arrested for an offense in Guadalupe County, is that right? Okay. Let's move on to the date of this incident. So how many drinks did you say you had at the bar? You were not drinking. You mentioned earlier that you were. Okay. Would it be a surprise to you if we go back to the record and say,
Right.
would it surprise to you if we go back to the record and say that you both were drinking?
Wait, so it's me?
Yes.
Said that we were both
Yes.
drinking?
Okay. So you got to your house around 3 a.m. Is that right? And you wanted to engage in sexual conduct with Miss Wise. Is that right?
I was okay with it. A little preoccupied on my phone at the time.
Okay. So it is your testimony that she was the one asking you to have sexual contact with her. Is that right? Okay. So what did she do when you told her that you didn't want to?
I didn't say that I didn't want to, I was okay with it, I was just on my phone momentarily.
Okay. And after that didn't happen, you mentioned that she got upset, is that right?
That's correct.
Okay. Was she the one assaulting you first, or were you the one assaulting her first?
She assaulted.
So you're saying that, so she was the one, is it your testimony that she was the one who assaulted you in these pictures?
Yes.
And why did she assault you?
Because I said something that was rude, I was vulgar to.
Okay. So is it your testimony that she assaulted you after she got this?
She assaulted me first. I was putting my hand out to protect myself.
And you hit her back? So how did she get this injuries?
Because I put my hand up while she was being that, while she was forcefully hitting me.
Were you aware that she got a broken nose?
I was not until she sent me the medical report, the hospital report that she got.
And do you think she could have gotten a broken nose just by putting your hand up, like you just motioned?
Well, she was forcefully coming at me, assaulting me. So very possible that the contact made with the angle of me laying on my back. All I had was to go up.
Okay. So how many times did you said she hit you?
At least 5, 6 times.
Okay, and where exactly did she hit you?
So one made contact with my eye, there, ear, neck, cheeks.
Okay, I can see the injury on your eye, but how did you get that if there's nothing, if there's not a punch around it?
Because I was poked in the eye.
So you were
By
poked
her nail.
with her what?
Now,
Her nail. And how did she hit the side of the left side of your cheek?
well, she was slapping me. If you can see here, there's some fingerprints here. There's red marks here, here as well as that.
So was she slapping you or was she punching you?
I believe she was just slapping me. I don't think she's. I would have gotten more damage if she was punching.
How could you not feel if whether she's punching or hitting?
I believe she was slapping.
Okay. So so your testimony that she was the one hitting you first, and as in self-defense, you got this injuries.
Sorry, say that again.
Is it your testimony that she hit you first, and this red marks and this injuries were as a result of self-defense?
That's a result of her hitting me. That's what it is. That's a result of self-defense.
But did you, okay, so right now we're looking at this, she also has a blood on her lips. Did you make this? How did she get this injuries on her lips? No, but we can see red marks and an injury, an actual injury on her lips. How did she get that? Okay.
She dried up blood on her.
Okay. And at what time exactly did you say you took the pictures of yourself?
Time exactly. I mean, it was shortly after it happened. I don't know the exact time, but it had to be after 3:30, I would say.
What, and where were you when you took these pictures?
I went into the guest bathroom to grab my shower stuff in my shower bag because I was leaving
You went to where? I'm sorry, I
to the
didn't.
guest bathroom.
Okay, to the guest bed. Okay,
All my stuff.
okay. At any point, did she ask you for ice or anything else for her bleeding?
She went to the bathroom. I heard her talking. I didn't really recollect what she was saying. My thoughts were, I just need to leave to get away from the situation.
So you didn't help her in any way after she was claiming that she was bleeding? Okay. Okay. And you were saying right now, you were mentioning something about cameras in the bathroom, right? The one that was in the bedroom where the incident happened, was it camera or was it a baby monitor?
The baby.
Just how long do those baby monitors keep data?
I don't know how long they keep data, but as far as I know, when there's a motion in the room or sound, it starts recording.
Okay, and do you know if that baby monitor needs to have a SIM card or something to record?
I would assume so.
Did you know if the baby monitor had a SIM card to record?
As far as I know, since I bought them, it did have a SIM.
No, but at the date of the incident, did you know whether it had a SIM camera or not?
I don't see why it wouldn't have.
Okay. Did you ask Ms. Wise for the recording of the incident?
No.
Why not?
Why would I ask?
Because you're claiming right now that she assaulted you. That's why. Did you
No, I
ask?
didn't ask.
No. You didn't seem important to you that if you're saying that she hit you, important to ask her for the recording?
She was accusing me of doing, really doubt that she would give me the money. So I didn't bother asking.
Okay. Okay, so when you were on your way to your mom's house and she was following you, did she ask for the keys of the house? Okay,
What she was telling me,
I didn't ask that. I just asked specifically whether she was asking for the keys. Did you have the keys of the house? Okay. So okay, so after when all this happened, how long were you and Miss Weiss together for?
after all of that happened,
Before.
we were together over a year and a half, I would say.
Okay. I have no further questions, Your Honor.
Right, defense?
Judge, I just need to clarify a couple things. Alex, the arrest that they're talking about was on the MTR that we're here for, correct?
Correct.
All right, you ever been to the Guadalupe County Jail? No. Okay. You ever received notice from them that there's a case pending? Okay, as it stands right now, today, there is no charge pending in Guadalupe County. All right. That's it, Judge.
Any,
No, Your Honor.
you may step down. All right, defense, call your next witness.
Judge, we rest on the motion.
All right, state any other witnesses?
No, Your Honor.
All right, and then I believe defense, you had some exhibits. I didn't get a chance to see
Oh,
them.
I'm sorry, Judge.
Sorry, that's okay.
Took them off.
Oh, no problem. All right. Cool. All right. So in regards to this case, any argument from the state?
Yes, Your Honor. The state has shown by a preponderance of the evidence that the defendant committed the offense of assault in Guadalupe County. We heard from the probation officer that they got the report, and that's when this violation report was submitted. Also, we heard from the probation officer that the defendant failed to submit to drug testing. as directed by the court in violation of condition number 20. Also, we heard from the complainant, Ms. Wise, and she explained to the court how she got these injuries, a broken nose, and this was after an altercation that happened between the defendant and Ms. Wise. So, Judge, we believe that we have shown this evidence, and for that reason, we're just asking the court to revoke the probation and sentence the defendant to 1 year in Bexar County Jail.
All right, defense.
Try to keep it all kind of together. There's always, been a lot about the situation that bothers me. And
Mr. Tochi,
can
you sit down so
you
can talk into the mic?
oh, yeah,
Thank you.
absolutely. The biggest issue that I have, Judge, well, of course, in any situation like this where there are no witnesses, and you have a girl with a picture like that who has blood coming out of her nose, I agree. She has dried blood on her mouth. I don't see any injury there. And there are no real witnesses. You just kind of have to evaluate their credibility, both of them. I never understood and never will why Miss Wise, who after being allegedly assaulted by Alex, doesn't do the one thing you would expect somebody in that situation to do, and that's to call the police immediately. Now, I know the court is aware and probably believes, well, there's probably a number of reasons that someone wouldn't do that. I don't understand that reaction, but I certainly don't understand the reaction to go and pursue the person that you claim to be the most fearful of. And I understand that she gave an explanation for that. But it just does not ring true to me or make any sense that she doesn't call the police. She talked about she was in a lot of pain and that her nose hurt, and clearly it was bleeding. She doesn't seek medical help. What she has in her mind and in her heart in the immediate aftermath is to still try to continue to hurt him and at some point his mother, by pursuing him 30 miles away to his mother's house where she knows she's not welcome. And then she starts to ridicule the both of them. And then she starts to threaten them about his child and her grandchild. And I really do think that that should go to her credibility. The report isn't made until a few hours after the fact, after she has tried to get Alex to come back home. She's chased him to his mother's house. And once she realizes that this isn't going to work, an allegation that he assaulted her is born. You have the pictures in front of you. And look, do I think Alex put his hand up and that and only that? No, there clearly was contact. There clearly was contact. She wants you to believe that Alex was really horny and didn't get sex. That was her testimony. And that is why he hit her. But when you look at the information that was presented to you, it was really quite the opposite. She was the one that was wanting to, they both were, especially her with some of the verbiage that she was. And it seems really, really silly that it would be born out of this, that he was denied sex and he just decides to start hitting her. Could that happen? Absolutely. But in her intoxicated state, mad, upset, could I see her climbing on top of Alex, pissed off, starting to hit him? Absolutely. Absolutely. And Alex not wanting that and reaching up because he was laying down and smacking her is an easy way to break a nose. I don't know. It's a self-defense technique. You probably may not be familiar with it. That'll break a nose quite easily. And Alex diffuses the situation by leaving, and she pursues and doesn't call the police and doesn't go to the hospital. And then in the aftermath of it all, now she knows, as she said, he's on probation. She has the upper hand. She has the upper hand and she knows it. And that's, the biggest part of this whole thing that I don't like is the fact that I 100% believe and cannot prove to you, I believe she has the video. I believe those video recording machines were working. They've always been working. You have the stipulated exhibit there where she tells the prosecutors, oh, I have it. Oh, I have it. And then at some point later in the future, oh, wait a minute, it got recorded over. The interview was on April 7th. The incident was February the 8th. If that video, if that audio, or whatever it is you had was that important, you are not gonna let that happen. That is literally the smoking gun. She's the only one with control. She's the only one with access. She's the only one that can delete, record, memorialize, or do whatever she wants. And we don't have it. And I absolutely believe those, the recording device was working, and she deleted it. I could kind of go on and on about her behavior, but there just is no reason for Alex just to go off over sex and do that. I understand that the burden of proof is really, really low. If the court finds it true, I certainly hope that the court doesn't lock him up for a year, Judge. He has children. He has gainful employment. I believe that Ms. Wise relies on his employment to help support Harlow, their child. And so I believe that it happened a lot more likely the way Alex told it versus her credibility. I find his credibility to be greater than hers. And I hope the court sees it that way as well. I'm asking the court to find it not true. If you do find it true, Judge, I'm asking you not to put him in jail for a year.
All right. Court is finding violation of condition 1 and 20 true. If y'all could do a trial court certification of defendant's rights to appeal for the court.
Mhm. Oh, that means you have the allegation true. And then tell you what she's gonna do. You would be-
And please don't check the boxes. I'll
No,
check
Judge.
whatever box is appropriate.
No, ma'am.
All right, thank you. Thank you.
Yes, ma'am.
These are always coming off the wall double. All right. As previously stated, the court is finding violations 1 and 20 true. Court is going to find the defendant guilty, grant the motion, and revoke. Does anyone wish to speak to punishment? The state is asking for a year. Defense, what are you requesting?
I mean, Judge, obviously not that. I mean, the court can continue him on supervision. The court has a ton of options that can be utilized.
We're going to continue him.
I mean, well, obviously I would ask for a very low term of jail, perhaps 30 days, Judge.
All right. Does anybody want testimony from probation as to how he was doing while he was on probation?
Well, I believe we already have that. Exemplary was the report from both POs. They had no issues whatsoever. I mean, that was my recollection, that they had no problems with him at
I
all.
just wanted that to be addressed because now we're at what it would be appropriate punishment with the revocation. So
Okay.
if anyone wants to speak to that, for the record, you can. I do recall what was said by
Yeah.
the witness.
Are you talking about Vashon, Judge? I'm sorry.
Oh, no. It's, if you want to ask Ms. Abrams some questions, or if you want the court to go on previous testimony from the probation officers who were supervising your client, I can go off of that as well.
Yeah, I'm comfortable with that, Judge. And that was the very reason that I asked those questions, because I figured we might get to this point. And I just wanted the court to understand that up to this, he would be, as I would describe, a model probationer.
Right. Anything else from the state?
No, Your Honor, other than the 2 violations that he committed, even though he was doing good on probation, he still committed those 2 violations. So that's all.
All right. What the court is going to do There's an affirmative finding of family violence. There's previously, I think I had ordered a no contact with Shelby Schultz unless it was through the parenting app. Now I'm going to change that to no contact with Shelby Schultz. And there is, does everybody agree that was the previous condition? Only contact through the app?
I believe it was, Judge. I didn't represent him on the previous case.
I just wanted to make sure.
Yeah.
All right, so there'll be no contact with Shelby Schultz. And then the court is going to sentence you to 180 days in the Bear County Jail. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Do you understand it and sign it?
Yes, she asked your question.
Sorry.
Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes. Yes, Your Honor.
I just have it. Yeah, the no contact. They haven't requested it, so. All right, because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations and the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. And counsel, this is your document. And counsel, if you want to check with the clerk on the days he has in. All right, thank you. All right, who's next? Who's ready? Yes.
Related to oath of God.
All right. Audrey, all right, on this case, I mean, I've already informed defense counsel, y'all waited too late to file a motion to withdraw. We're at jury trial stage, so.
Well, Your Honor, if I may,
Yes.
we were hired on this case in November. Mr. El Gadrab failed to appear to a hearing back in November. As
Because he was currently in a hospital, and we were waiting for documentation, and documentation was provided.
yes, and documentation was, I don't believe documentation was provided, Your Honor. We attempted to reach out to Mr. El Gadrab, but there was no communication returned. We lost communication as a courtesy for him. To attempt to reestablish communication, we waited a couple of months. We filed a motion to withdraw in January. I attempted a few times to address that with the court, but because there was an active warrant, that was not considered until he was arrested and brought before the court. And the first opportunity we've had to address that filed motion back in January in front of the court was today. So that's why the motion to withdraw is being urged today in this matter.
When were you all hired for this case?
When?
When?
November 11th, I believe. Yeah, it was November 11th we were hired. We filed a notice of appearance on November 11th, which was a holiday.
Okay, so you all filed it on November 11th of 2025?
Yes, sir.
All right, so he had previously had an attorney representing him before you all were hired. So this case is going to trial and you're his attorney. So y'all gonna be back tomorrow.
I never request for the trial either,
Hmm?
I never request for trial either.
All right, well, we'll see what happens tomorrow.
Your Honor,
Yes,
like I said, Mr. El Gadrab failed to cooperate and maintain adequate communication with us. He, at that point in time, severed any sort of attorney-client relationship at that point. We've had no opportunity to address the case with him, talk about any possible defenses. Additionally to that, we learned that he is not a U.S. citizen. I have not had the opportunity to discuss matters with him in relation to us at D11.
I'll see y'all back tomorrow for jury trial on April 29th, and whatever y'all need to discuss with him, discuss with him. Because what I do know is he had been represented by an attorney at the beginning of May of 2025. Then you all were hired. And now you all went off. I mean, his trial is upcoming and he's saying that he doesn't want a trial. So I'll see you all tomorrow. All right, who's next?
Your Honor, if I have,
Who do you have?
but I don't have any more, Your Honor, but I have more to present to the court as to why. we're not
Sure,
going-
you want, we can present more. All right, the court is calling 2025 CR 004768 State versus Mahmoud Al Gadrab. If you'll come back. Can I have parties announced?
Lauren Espinoza for the state.
Mario Moreno for the defendant, Your Honor.
All right, and are you Mr. Al Gadrab?
Yes, ma'am.
All right, the court will note for the record, the defense off the record told the court that they were seeking to withdraw from the defendant's case. The defendant previously had an attorney, May 2025. Defense counsel was hired according to the defense, November 2025. We are now here for a jury trial, and the defendant has been in custody since, I believe, was he placed in custody?
It's the state incident.
I'm sorry? March 8th. He's been in custody since March 8th of 2026. And so this is scheduled for jury trial today. And I'm sorry?
I was not in this county.
That's okay. You were in Hardin County? Yes, since March of 2026. This case is set for jury trial today. The case was previously set for jury trial on January 7th, 15th, 2025. And then it was reset for jury trial on November 12th, 2025. Defense counsel was hired, and when that case was set for jury trial on November 12th, 2025, it was set on September 15th. I'm sorry, for the record. It was set on September 15th, 2025 for jury trial and a plea deadline date on November 12th, 2025. And then defense counsel was hired in November 2025. And so this is set for jury trial. Defense, you want to place something on the record?
Yes, Your Honor, and I was not aware that we weren't previously on the record, so I will
It's okay.
retain everything I had previously said. So Mr. El Gadrab did hire our firm as a Barton and Associates law firm back in November 11th, 2025. There was a jury trial scheduled at that time, but Mr. El Gadrab did not appear for that date. We were informed that he was in the hospital and would provide, and this was not information that was provided to us directly from Mr. El Gadrab. We were told by an associate that he was in the hospital and would provide details to provide to the court as to potentially excuse his not appearance on that day, but we did not receive that information. We lost contact with Mr. El Gadrab and he failed to maintain and cooperate with our law office. Thereafter, we, in order to give him some sort of benefit of the doubt and give him some chance, we held off on a motion to withdraw until January of 2026 because we failed to establish contact with him at that point. I attempted several times with court to present a motion to withdraw earlier in the year after it was filed on January 26th. But the court refused to hear that motion while Mr. El Gadrab had an active warrant and was not in custody. So it wasn't for any lack of our firm or the defense attorney's attempt to obtain an alternate attorney for Mr. El Gadrab at that point. We were told that it would not be entertained until he was in custody and in front of the court. And the first opportunity that he was in custody or in front of the court was today. And so that is why we're attempting to withdraw at this point in time when he was set for trial. When I attempted to schedule it for a motion to withdraw hearing prior to today's date as well, but I was unable to get that scheduled due to court scheduling over the past couple of weeks. Mr. El Gadrab has had little to no contact with our office to prepare for trial. Additionally, he is in need of a Padilla letter with admonishment from an immigration attorney. I've had no communication regarding that with him to prepare for that or to get an understanding of what that might look like. He's had no admonishments from an immigration attorney about his potential consequences. We are not prepared to accept any offers or prepared to go to trial due to these reasons. If I was to go to trial without this information on Mr. El Gadrab, it would be ineffective assistance of counsel at that point. I think it is in Mr. Elgadrav's best interest at this point, because the attorney-client relationship has been severed due to his cooperation with our office and inability to communicate, that we be withdrawn, he be appointed an attorney by the state. And that he have an opportunity as well to get potentially an admonishment from an immigration attorney for Padilla, so that he can understand what his potential consequences are in this case. This is a case involving moral turpitude.
Oh, yes, and with cases involving moral turpitude, if you are not a citizen, then if you are found guilty, if you enter into a plea bargaining agreement and it's a crime of moral turpitude, you're deportable. Yep, the motion to withdraw is denied. You all need to discuss. If you don't want to talk to him, what's going to end up happening if you're going to go to trial with an attorney you have not talked to. So, thank you. All right, I'll see you all tomorrow. All right, who's next?
I have,
Ethan J. Castillo. Court is calling 2025 CR 0074447 State versus Ethan J. Castillo. Can I have parties announced?
Or Espinoza for the state.
Right?
And are you Mr. Castillo?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Ethan J. Castillo who was placed on deferred adjudication in 2025 CR 0074447 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on October 23rd, 2025 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 12th day of February 2026 in Bexar County, Texas, the defendant Ethan J. Castillo committed the offense of burglary of vehicles in violation of condition number 1.
How do you plead to that? True or not true?
It's true.
Violated condition number 4, in Bexar County, Texas, the defendant Ethan J. Castillo did then and there fail to report to the supervision officer as directed for the month of January 2026 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State will waive the remaining alleged allegation.
Any objection to the waiver?
No.
Did you understand by pleading true to violation 1 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violations 1 and 4?
Yes, ma'am.
Court will find 1 and 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to deny state's motion, alter and amend for SATIF.
All right. Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. And what is happening with the new number 1?
The new number 1, Judge, was already closed out and pled on.
Okay. All right, the court will deny the motion, alter and amend conditions to include and the following in custody. Status, and if not accepted, I'm sorry, let's do felony drug court referral. Is he eligible for that?
Judge, it was already a felony drug court referral, but we can do another one.
All right, so in custody, do a referral to felony drug court. If not accepted, then SATIF, and he's to remain in custody until accepted into felony drug court or SATIF. All right, is there anything else?
Nothing. Thank you, Judge.
All right, thank you.
Thank you, Judge.
Who's next? Yes.
The state just wanted to request a no contact order with the current complainant.
All right, if Mr. Toshi, your client is not present and they're requesting that there be a no contact order with the complainant as well. Is there going to be any objection to that?
Well, I mean, after he gets out of jail.
No, that's what I'm saying.
Well, I just don't think it'd be appropriate. He's no longer on supervision.
Well, this is what I'm going to tell both parties. Number 1, whenever a defendant is not present, if I'm being asked to change any type of condition and they're not present, if it's something to their detriment, I'm not allowed to do that unless they're present and they're not here. So if you want the no contact order, then they'll need to be called back.
Mr. McCray.
Can we just call, I think it's.
I mean, you'll have to talk to the deputy.
But can we confirm for?
Yes. Who's next?
Judge.
Jeffrey Dollar?
Yes,
What's happening with your case, Mr. Cox, too?
Ma'am,
What's happening with your case as well?
we'll confirm, but, I believe my client says she wants to have a jury process.
All right, just give me a moment with Mr. Dollar, then I'll take you right up. Jeffrey Dollar? Hello. Court? Okay, this is a PSI, am I correct?
It's a sentencing. It was a 2-week reset for sentencing. You gave us the option of a PSI
Yeah.
or no PSI. We chose for the more expedited approach.
No, it's just that there's a file stamp on here that says it's something else, but okay. All right. 2025 CRs 007775 State versus Jeffrey Dollar. Could I have parties announce?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
And are you Mr. Dollar?
Yes.
All right, so in this case, the PSI was waived. You entered a plea. The court found there was sufficient evidence to find you guilty. The court found you guilty. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. There are no applications. This is run concurrent with 2508157113 CR out of Medina County.
Yes.
Any witnesses from either side?
None from the state, Your Honor.
Not witnesses, just a few exhibits for the court as evidence.
All right, any objections to the court reviewing the documents?
For the benefit of the record, my client, while in jail, has undergone various programs. Specifically, he's attended 8 sessions of AA. He's attended 10 sessions of substance abuse curriculum. He's completed the peer mentor program. He's participated in the MAT program, and he's completed 21 sessions of Narcotics Anonymous. We're asked court to take these certificates and these completions into evidence as part of the record.
All right, the court has reviewed the documents and the court will take that into consideration when passing sentence.
Yes.
And all we have left is just argument, Judge, so we'll close our evidence.
All right, state.
Your Honor, we're asking that you sentence Mr. Dollar to the cap of 10 years. Mr. Dollar does have criminal history. This history does not only stem from drug cases, but also firearm possession, as well as victim cases such as the UUMV and then the instant case here as being a robbery. Mr. Dollar was sentenced to 46 months confinement with 3 years of supervised release federally, as well as 21 months with some supervised release subsequent to that confinement. Both of those federal probations resulted in revocation. Additionally, he also did straight time in both state jail and TDC in Bexar County and Amarillo in Potter County, Texas. Because of his criminal history, Judge, I believe that Mr. Dollar would not be a viable candidate for probation. He has shown in the past that he.
I'm sorry, there's no application.
I'm so sorry.
That's okay. It's
sorry,
been a
Judge.
long day. It's fine.
Because of Mr. Dollar's prior criminal history and his subsequent revocations, I don't believe that he would be a viable candidate for a sentence less than 10 years because he's already done a significant amount of time and continues to put himself in situations and make choices that show that he is not a law-abiding citizen. So because of that, Judge, we'd ask for the cap of 10.
All right, and defense.
Judge, we're going to ask for a sentence on the lower end. As you can tell from the reports, so to be clear, he knew this individual, the complainant, from a prior dating relationship. She maintained possession of an item that was his. He went about this absolutely the wrong way and the illegal way, but he went to her vehicle to try to retrieve it. She intercepted him, and in the process, he used physical force against her. It's in going over the evidence with him, and showing him how he went absolutely wrong. In reviewing the evidence, he agreed. He realized that he messed up. He took ownership of that, of breaking the law. And we're asking the court to consider the following, that I'm the second attorney on the case, but he met with me, he was up forthright. We looked at the evidence, and after reviewing the evidence, we approached the court and set up this plea negotiation. And I'm mentioning that he didn't want to belabor this with a trial. He accepted responsibility immediately. So we're asking the court to sentence him on the lower end of the range, because he's taking responsibility. He went about, this was not necessarily a random act. He went about trying to get some property absolutely the wrong way, but that's how this action unfolded. So for that, Judge, we're asking for the lower end.
All right. The court, as previously stated, has found you guilty. There's to be no contact with the complainant. The court will order the therapeutic community. This is run concurrent with 2508-15713 CR. That's the case out of Medina County. There's a $2,000 fine, time and money to run concurrent. Credit for any time served, no residing in households with minors, no unsupervised contact with minors, and the court will sentence you to 9 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. You understand?
Yes.
All right, and I appreciate the fact that you were using your time wisely to try to better yourself. I took all of that in consideration, okay?
Thank you.
All right, thank you. Have a good
Thank
one.
you, Judge.
Judge,
Thank you.
before, excuse, we have the complainant on Zoom for victim impact if the court will allow.
There's nobody on Zoom. If you,
Bubbles are typing. I just confirmed if she was on Zoom. She said yes, but now I have bubbles if I can have one second.
okay, if you want to, if you want her by phone,
Phone?
yes,
Okay.
and you can just do a conference call. All right, Wilkins. You want a jury trial?
Yes, I do. Okay,
All right, we'll see you tomorrow.
okay, thank you.
Have a seat, Chris.
All right, Mr. Cox, we'll have Mr. Wilkins come back tomorrow. If we could put it June.
Thank
you. All right, so we'll be back on June 1st, and that will be your plea deadline date.
Yes, ma'am.
All right, thank you.
Think about it.
Yes.
For radio and music, it just go
Okay,
over that.
sure.
She claims that she's in the waiting room, Judge. I don't know.
Oh,
If not, I think we just.
no, it doesn't show her at all. State, it doesn't show her anywhere. All right, so I think this is the last one. Have you had a chance to speak with him? Does he want to have contact?
Well,
Is there a reason for them to have contact?
they have a child. And so that's just kind of what makes it.
All right, they'll have to, I mean,
I-
you know,
I-
that's something maybe through a third party.
The issue that I'm trying to figure out is, I don't know, is there statutory authority that can add no contact on a jail sentence?
Yes.
There is, there might be, I've never encountered it. I guess if they want to file something, but they do share a child and he would like to be a part of that child's life.
I mean, he can still be a part of the child's life. He just have to do it through
Right,
third parties.
right, and I'm fine with that.
Yeah.
But, and maybe I can chat with them about that, and then we can.
So you,
The state is just requesting no contact order with the complainant Olivia Weiss. She does.
it doesn't, I'm not gonna do a no contact with the child.
Understood.
Yeah, it just be,
And if the court orders it, I'll object. If the court orders it, I understand you, you're making your ruling and.
right, let's bring him up here. I'm trying to find him on the docket. Thank you, so I can do the cost center. All right, we're back on the record in 2024 CR 3533, State versus Alex Miosek. Can I have parties announced?
Want to get agenda for the state?
James Tochi for Mr. Masek, Judge.
And you're Mr. Miosek?
Yes, ma'am.
All right, Mr. Miosek, the court has already sentenced you, but the state is asking that you have no contact with the complainant. Do you have any objections to not having contact with her?
No.
All right, so your counsel has informed me in state off the record that you all have a child together.
Yes. ma'am.
So normally what happens in situations where there are issues between the parties, then there is some third party who's able to help with visitation and do exchanges. Now, I will tell you this, I will do the no contact order, but I will add to the order that, of course, if there is a child emergency, we hope that it doesn't happen, but sometimes it does happen. Well, maybe the child has to go to the hospital for a tonsillectomy or something, that you're allowed to be there.
Yes.
So there will be no contact with the complainant outside of emergencies related to your child. Okay? And let me put that in here just 1 second. All right, is there anything else? We're done for today?
Thank you, lady.